So let's go through assignment number 1. I'll read the facts. 5 months ago, your client moved to city A, or city and state A from a different state, and she wants to run for city council. Your research reveals that there's no ordinance defining residency, and state A doesn't have a statute addressing the residency requirements for municipal elections. But there is some authority to work with, and so let's go through it. State A has a statute which provides that a candidate for the Supreme Court must live in the state for 3 years. State B has a statute that defines individuals running for any county or municipal office must have resided in the county or municipality for 6 months. And then there's a case, Garcia versus Municipality of Weston. It's a court appeals decision providing that a person running for a state senate must reside within the Senate district for a minimum of 1 year prior to the election. And then last is Risen versus City, and State B Supreme Court holds that a person running for municipal elections must reside in the municipality for 3 months. Okay, and then there's an AmJur article that provides most states have a 3 months residency requirement to run for municipal opinions. So let's go through questions A, B, and C and see if we can figure this out. Okay, question 1. Which authority is primary and which is secondary? The answer is number 1, number 2, number 3, and number 4 are primary authority. Remember, primary authority is the law. Secondary authority is the AmJur article because secondary authority explains the law. Okay, so if we have a statute or a case, that is primary. If we have an encyclopedia or some legal scholar talking about what they think the law is or what the law is, that's secondary authority. Okay. Number B, which, if any, of the authority is mandatory authority and why? Well, I think the answer here is none of them are necessarily mandatory authority. Remember, mandatory authority is authority that the judge must follow. Okay. So let's look at them. Okay. State A has a statute about Supreme Court judges. Okay. Now, since we are in State A, if this was a case about Supreme Court justices, it would absolutely be binding and mandatory. The problem with this is that this is a municipal election, and a good attorney would make an argument, well, there's a different reason for having someone who's on the Supreme Court live in the state for 3 years. Okay, so it is, in a way, mandatory authority, but it is not on point to the facts at hand. Okay. Number 2, State B has individuals running for any county office must live in the municipality for 6 months. Okay, this is not mandatory because it's from State B. Okay, it would be persuasive authority because the judge in this case, if he can't find a law or a case directly on point in his state, could look to this and say this makes sense and I'm going to adopt it. Okay. Number 3 is the same as number 1. The Garcia versus Municipality of Weston is a state court decision that a person running for state senate must reside in the district for 1 year. Okay. It's mandatory in a sense that it comes from State A, but it is not mandatory in the sense that it doesn't apply to municipal elections. Okay. So if it was about a state senate seat, it would definitely be mandatory authority and the judge must follow it. In this case, you could argue that it really shouldn't, there should be a lesser requirement for a municipal election. Okay. Number 4, State B. Okay, anything from State B is not going to be mandatory authority on a judge in State A. So in that sense, it's persuasive. And then number 5, an AmJur article is always going to be persuasive authority because it is not the law. It's just an explanation of what somebody thinks the law is. Okay. Question number C, which authority can be persuasive authority and why? Well, the answer is, in a sense, all of them could be persuasive authority. Number 1, about the state Supreme Court, you could argue that a municipal officer is the same as a state officer. So you could argue that, but it wouldn't be very persuasive in my mind to a judge. Okay, the requirements for a state Supreme Court member are going to be much more strict than for a municipal, member of the city council or county government or whatever it might be. Okay, number two is definitely persuasive authority because the facts are very similar. Okay, State B, which we're in State A, remember, has a statute that says anyone running for municipal office should live there 6 months. Okay, so a judge might consider that in his decision, saying, okay, State B says 6 months, so I'm going to adopt a 6-month requirement in State A because there's no statute from the legislature directly on point. Okay. Number three, State A Supreme Court decision could, State A Court of Appeals decision, Municipality of Weston, that a person providing for State Senate should live there a year. Again, a good attorney would say that the requirements for a State Senate seat should be more strict than a municipality. And if I was representing the guy that wanted to run for the city council, I would say, hey, it should be less for a municipal officer than it should be for a state senator. Number four, again, we have State B. Anything from State B is just going to be persuasive authority. And it does say 3 months. Okay, so if I was representing this person, I would say, hey, look at State B. They have adopted this, and I think you should follow it here. The reasoning in that case is really good, and 3 months is just about right. A year is too long, 6 months is too long, and we'd leave it up to the judge to decide. Okay, now number five would be very good persuasive authority, but not mandatory in any manner because it's an AmJur article. And if I was representing this guy, I would say, or this gal, I would say, hey, look at AmJur second. Most states say 3 months. Okay, since most states say 3 months, we should adopt a 3-month residency requirement in this state as well. Okay, I hope that is helpful to you. If I went through it too fast or you're still confused, email me and we can set up a time to talk over the phone or Skype or whatever. Now we will move on to the second assignment for the week, which is statutory analysis. The statutory analysis assignment has 3 different criminal codes or laws or statutes that you need to interpret and apply to the facts at hand. Okay, number 1 has to do with burglary, number 2 has to do with robbery, and the third one has to do with larceny. Okay, so I'm not going to read each of those. You have that, should have that in front of you when you're going over this video. I'm going to get right to the 4 questions. Let's start with question number A. Okay, Denise asks Larry to hold her shopping bag for a minute while she makes a phone call. When she looks away, Larry absconds, means takes off, with the shopping bag. Which statute has Larry violated? Well, let's go through them. Burglary. No, it's not burglary because all of the elements of the crime have not been met. He did not enter unlawfully into a building or occupied structure. So it is not burglary. Number 2, robbery. Knowingly takes anything of value from the person or residence by use of force, threats, or intimidation. The answer is no to that as well, because Denise asked Larry to hold the purse. He didn't force her to give him the purse, so it is not robbery. So let's look at the last one, larceny. Someone who wrongfully takes or obtains or withholds by any means from the owner money, personal property, with the intent to permanently deprive them of the use and benefit is guilty of larceny. Okay, larceny seems to fit here because he did abscond or leave with it. So he did wrongfully take, obtain, or withhold the purse from the victim here, Denise. The only issue is whether he intended to deprive her permanently of the item. Now, Larry might get on the stand and say, hey, well, I was going to give it back to her. It was just a joke. Or I only wanted to look into it because, I don't know, I have some fetish about women's purses, okay? Well, that may or may not be true, but the reality is, tell that to the jury and let the jury figure it out. And, in my experience, 99% of the time, they're not going to believe Larry, and they're going to presume from the facts that he did intend to keep it because he left with the bag for no really good reason. Okay, that's question A. Question B. Larry attempts to steal a lady's handbag. He grabs it as he runs by. She refuses to let go and a struggle. Finally, she lets go of the bag and he escapes. Okay, which of them has he violated? Not burglary, because burglary you have to unlawfully enter some type of dwelling or building or something like that. Okay, robbery is definitely here. Okay, because he knowingly took the thing by force. Okay, any amount of force is okay usually. So here he would have grabbed the purse and she struggled and he took it. Okay, the elements of robbery are met. Okay, larceny would probably be acceptable as well because he took it with the intent to permanently deprive her of the purse. Okay, the difference between robbery and larceny is the use of force. Okay, so he could be charged with both. He could be charged with robbery and larceny. Robbery generally being more serious because we consider violent crime a more serious offense because generally somebody can get hurt. Okay. C. Mike has several drinks and runs up a tab. At the end of the evening, he asks the bartender asks him to pay up. He refuses, threatens the bartender, and leaves. Okay. Now, not burglary because we don't have any unlawful entry. Okay. Maybe robbery because he took from another the drinks with an intimidation, which is he threatened the bartender and leaves. Okay, it would be a close call. I would probably say this really doesn't really fit into the larceny category because, or it doesn't fit into the robbery category because in robbery, usually the force or the threat of force is at the time of the taking. Okay, so but we do have larceny. Okay, he wrongfully took the money or took the drinks and didn't pay for them. Okay, so it fits into larceny. The argument Larry might make is well, at the time I intended to pay, but then I decided I didn't want to, or I realized I didn't have any money and I freaked out. Like I said, tell it to the jury. Probably he's guilty of larceny here. Okay, the last one, question D. A family lives in an old school bus. Don, searching for something to eat, enters the bus while the family is away. He takes soup, loaves of bread, and then he leaves. Okay, well, what did he commit? Okay, is it burglary? In actually some states it would, but let's look at the statute at hand and analyze that. A person commits burglary if they knowingly enter or remain unlawful entry in a building or occupied structure. The key here is a bus an occupied structure? The answer is I don't know. Okay, what we would do is we would go to the cases interpreting the statute and see if we could find any where an occupied bus is considered an occupied structure. Okay, the key word here is structure. Is a bus a structure? The answer is I don't know. In some states it actually would be. It could be a robbery if you actually break into somebody's car. It's not robbery because there's nobody there at the time, so there's no one to threaten with the taking of their property. Okay, larceny, it's definitely larceny because he took the soup and bread, and it really doesn't matter whether he was starving or not. Okay, the law doesn't look into that. The intent was, there are some exceptions to the law. For example, extreme necessity, like you break into a cabin in the woods in the freezing winter, and but that's pretty rare. Okay, so we have a larceny here for sure. Okay. The burglary is a little more questionable. Hopefully that was helpful for you. I will probably each week post videos, and like I said, it's easier than writing individual answers. If you have any further questions, don't hesitate to contact me.